Hello, welcome back to Law at Home. We are still in our series on land ownership in the Philippines, and we are on our third episode on the formalities in land application. So last week, we started discussing about the Torrens system, and thanks to Sir Robert Torrens, who first used and introduced this system of land registration. Okay, and last week also we started already as the start of the formalities in land registration, the question as to who may apply for registration. And we already answered that last week. And today we're going to discuss in details about this application, the formalities of this application. Okay, so are you ready? But before I continue again, I encourage you to send your questions, your comments, to the comment section below, or you send a message to our Facebook, Attorney Rico Rentuza, Law at Home. All right? So we're going to discuss now the essential requisites for original registration. And if you remember, kung maalala nyo, we discussed about the previous laws about land registration. And one of these old laws, but still applicable, but still in effect, is Act number 496, or the so-called Land Registration Act of 1903. Can you imagine that? But we're still using it now. Okay, and I'd like to discuss with you the process already, and we'll focus on the formalities of this petition or this application for land registration. Okay? So, based on this law, Land Registration Act or Act 496, we have these requisites. The first would be the survey of land by the Bureau of Lands or a licensed private surveyor. Why is this important, no? Mahalaga itong survey of land. And hindi lang basta-bastang survey. Kasi if you siguro pag may experience kayo sa mga rural areas, minsan yung municipal assessor ay may survey din sila. But if you look at it, hindi yan, walang technical description yan. So mga estimates lang yan. So the survey of land that we're talking here is talagang the one conducted by the Bureau of Lands, by their engineers, or by a licensed private surveyor. And the end product that we are looking at here is the survey report with technical description. Why is this important? Again, going back to the Regalian Doctrine, di ba? The general rule under the Regalian Doctrine is all lands of the public domain belong to the state. So yun ang general rule, no? If you look at it, yung buong lupa ng Pilipinas, okay, ay pagmamay-ari ng Estado. And if you want to apply for title to a specific parcel of land, kailangan mo ito. Why? For identity purpose. Anong portion ng land of the public domain ang kiniklaim mo at in-applyan mo ng title? So with this survey of land, we will see the meets and bounds, no? Sinabing meets and bounds, yung mga boundaries. Sino bang mga kaninong property ang adjacent sa'yo, no? Yung katabi mo. At from point to point, no? Yung mga tinatawag natin dito sa Bisaya, mohon. I don't know in Tagalog if it's also mohon. So from one mohon to another, ilang meters ba yan? So the distances and the shape of the land that you're applying for, makikita din doon. Okay? So it will be a very detailed description or specification of the land that you are applying for. Kailangan ito again because you want this piece of land to be taken out of the land of the public domain para magiging private ownership mo. So, kinakailangan na identified siya. That's the most important thing. Kasi pagdating doon sa court, if the court will see na hindi pagmalabo yung ina-applyan mo, the court cannot act on it. Okay, so that's the first, the survey of land by the Bureau of Lands or licensed private surveyor. So in short, you can go to the DENR kung saan sila yung deputized ng Bureau of Lands to conduct survey na magiging official yan. So dapat may pirma yan ng engineer from the Bureau of Lands or from the Department of Environment and Natural Resources. Or you can hire a licensed private surveyor, okay, na authorized to conduct survey. Okay, yung mga geodetic engineer talaga. Okay, para pang pirma nila, ma-acknowledge doon. Okay? So, if you are planning to apply for title, file an application for registration, ito ang una mong gawin. Okay? Have it surveyed. Have it surveyed. Okay? So, pag meron ka noon, now, you can now file your application. Again, we are talking here of judicial process of acquiring this piece of document, the Torrens title, para maging registered yung land mo, ha? So, daan tayo sa court. Again, we will discuss later on yung administrative process na sinasabi natin last week. So, again, para malinaw sa atin, ang dinidiscuss natin ngayon is the judicial process of land registration that we are going to apply in court. Okay, so this is what we call judicial titling. Alright? So, pag meron ka na ng survey, mag-file ka lang ng petition. So, i-discuss natin ngayon, anong formalities na kailangan sa petition or sa application ng title mo. Now, two things. But this para sa akin, not because I'm a lawyer, but you have to, mas maganda if you seek assistance, no, ng counsel, ng lawyer, para mas madali sa'yo, mas mabilis. But I think, I don't know kung meron pa ba ngayon na nag-a-apply on their own, a non-lawyer applying, pwede din siguro because may form. No? Kaya we will discuss it now, yung mga formalities on this application. Okay? And from the Act 496, Land Registration Act, we go back to PD 1529, yung Property Registration Decree of 1978, kasi doon nakalagay ang formalities, itong application. Anong dapat isusulat doon? Anong dapat naka-allege doon? Okay, sa petition or application mo for land registration. So, you read section 15 of PD 1529. And I will read with you section 15 of PD 1529. So, it says, the application for land registration shall be in writing, signed by the applicant or the person duly authorized in his behalf, and sworn to before any officer authorized to administer oaths for the province or city where the application was actually signed. If there is more than one applicant, the application shall be signed and sworn to by and in behalf of each. The application shall contain a description of the land. Okay. Description of the land. Saan mo kukunin itong description na ito? Doon sa survey of land. Kasi meron doon, di ba, yung technical description. Sa west, sa north, sa east, sa south, anong mga property ang naka-bound sa kanya, yung meets and bounds, at saka ilang meter. May mga ano pa yan, degrees. So, yung mga engineer lang ang nakaalam yan. So, dito sa petition mo mismo, you state the description of the land using the description na nakalagay doon sa survey of land mo. And then, it shall state the citizenship and the civil status of the applicant, whether single or married, and if dissolved, when and how the marriage relation terminated. It shall also state the full names and addresses of all occupants of the land and those of the adjoining owners, if known, and if not known, it shall state the extent of the search made to find them. The application shall be substantially as follows. So if you read section 15, PD 1529, meron pa doong sample, okay, ng application. So, actually, you can really do it, no, without the assistance of lawyer kasi meron doon, no? If tingin mo kaya mo, pwede mong gawin yan, ipanotarize mo na lang ng abogado and then you file it in court. Okay? And sa form dito, nakalagay, no? If you look at the form suggested by Section 15 o PD 59, nakalagay dito, of course, yung heading, no? Republic of the Philippines, then Court of First Instance. Sinabi ko na itong Court of First Instance, this is the old name na ginagamit. Ito ngayon, Regional Trial Court na ito. Then, sinabi dito, the undersigned, blank, of course, the name of the applicant, hereby applies to have the land hereinafter described brought under the operation of the property registration decree and to have the title thereto registered and confirmed and declared. So, paragraph number 1, that the applicant is the owner of the land. Okay, and you state there how you were able to acquire your ownership, no? By virtue, for example, of inheritance, sinabi natin, by succession or by sale or conveyance, okay? Or possession, yung sinabi natin, you own the property by prescription. You possess it for a period, for a certain period required by law, di ba? You remember, ordinary prescription, 10 years, extraordinary prescription, 30 years. Okay, in accordance with Section 14 of the decree. Together with the building and improvements thereon. So pag may mga improvements yan, isama mo rin doon, isite mo rin dito, no, sa application mo. With the exception of the following. Okay? So pag may mga property inside it na hindi sa'yo, pwede mong sabihin na, no, kaagad dito. Then paragraph 2, that the said land at the last assessment of taxation was assessed at, so ilagay mo yung assessed value. Saan mo makikita ito? Sa tax declaration. Pag may tax declaration yung property mo, doon nakalagay yung assessment. So ilagay mo rin dyan. Okay? Pag may mga buildings yan, improvement, at saka may tax declaration din yan, i-state mo rin doon yung assessed value ng property. Okay? Then number 3, to the best of my knowledge and belief, there is no mortgage or encumbrance of any kind whatsoever affecting the said land or any other person having an interest therein, legal or equitable, or in possession other than as follows. So pag may, for example, your property is mortgage, for example, so nakasanla yan, ilagay mo rin dito. Why? Bakit important? Because lahat ng tao na may interest sa properties, of course, di ba, yung banko, for example, or your lending company, or yung private individual kung saan ginagaranti ang lupa na ito for a certain loan, interesado yan sa property, no? Kasi whatever happens, pag hindi nabayaran yan, di ba, they will go after the property. So may interest sila. So, good faith requires, and the law requires, na kailangan mong sabihin doon para malaman ng court. Okay? Para ma-notify sila. Because otherwise, they can also complain later on na hindi sila nino-notify, na may interest sila sa property. Okay? Okay. Now, number 4, that the applicant has acquired the land in the following manner. So, na-mention na ito sa paragraph 1, pero i-specify mo pa rin dito. No? Kaya in fact, i-attach mo pa yung mga proof mo of your mode of acquisition. Pag deed of sale yan, i-attach mo yung deed of sale. Okay? So, meaning, the details of your mode, the detail of the mode of your ownership o acquisition of ownership, kung paano mo na pagmamay-ari ito, you have to state here in this paragraph. Then, number 5, that the said land is occupied by the following person. Pag merong mga occupant yan, for example, nabili mo yan, meron ng mga occupants, for example, tenants, or for example, may nakatira dyan, by tolerance or by permission of the previous owner, i-state mo rin dyan. Okay? Kasi interesado din sila because they are in actual occupation or possession of the property. Then number 6, the full names of the owners of the adjoining properties, sabihin mo rin yan. Kung alam mo, of course, dapat alam mo kasi dapat may due diligence ka, di ba, when you acquire the property. And pati sa technical description mo, sa survey, makikita yan eh. Kasi dapat i-notify din sila sa surveyor, yung mga adjoining, owners ng adjoining property. So, sabihin mo rin dyan. For example, sa south, ang may-ari ng property sa south ko ay si A. Sa north ay si B. Sa east ay si C. Sa west ay si D. No? So, i-mention mo yan lahat dyan. Okay? Then, that the applicant is single or married, no? Pag married, kung anong pangalan ng asawa, i-mention mo rin dyan. Pag na-terminate na yung marriage, for example, may annulment or declaration of nullity, i-mention mo rin dyan kung paano na-terminate yung marriage. Bakit? Kasi papasok doon yung batas sa community property, doon sa under the family code, or pag yung marriage nila is governed by the civil code before the family code. Of course, conjugal partnership of gains, no, or property. So, importante ito. Kasi pag in-apply mo yan and you are married, nire-require yan. No? Kasi para malaman yung status ng property pag nag-grant na sa'yo. Then, full name, age, citizenship, residence, and address of the applicant. Kailangan ito, di ba? Bakit citizenship kailangan? Because sa batas natin, only Filipino citizens, natural-born Filipino citizens ang pwedeng magmamay-ari ng property. We will discuss later on itong issue na ito, itong usapin na ito about aliens, no? About non-Filipinos owning land. And generally, only Filipino citizens. May mga nuances ng konti, may mga exceptions yan. Okay? And we will discuss in detail doon na sa problem areas ng land registration and land ownership. Okay? So basta kailangan i-declare mo yung citizenship mo. Okay? Then number 9, that if the land included in the application is bounded by a public or private way or road, there should be stated in this paragraph whether or not the applicant claims any or what land within the limits of the way or road, and whether the applicant desires to have the line of the way determined. So, if your property in-applyan mo ay located or bounded by a public road or a public land or a private way, dapat naka-state din dyan. At saka kung anong claim mo sa private or public road na yan. Okay, important din ito. Then, the following documents, dito na, state mo kung anong mga attachments mo. Of course, importante doon ang survey of land. Number 2, yung mga proof of ownership mo, how you acquire the property. Again, if sale, deed of sale. If inheritance, baka may mga extrajudicial settlement and partition kayo ng mga co-heirs mo. I-state mo rin, i-attach mo rin yan dito. Or if you acquired it by virtue of donation, yung deed of donation, or by virtue of a grant, okay? By a public grant, no? Pwede rin dyan. Or if by possession, okay, siguro yung tax declaration as proof na nag-possess ka dyan and you are paying taxes. So dito, importante yung tax declaration. May mga ruling ng Supreme Court na yung tax declaration, of course, is not proof of ownership, but it is a proof that you are paying the real property taxes over that property, and coupled with your actual possession, pwede yang gamitin mo, no, as proof of your claim of ownership. And if yung possession, actual possession mo and your payment of taxes ay papasok doon sa period, okay, of prescription, mabigat na katibayan yan of your title over the, or your ownership over the property. Okay? At pagkatapos, yung signature mo. Kung kailan ang date na pinirmahan mo, kung saan mo pinirmahan, ideally or dapat kung saan, no, pinafile mo yung petition. And, of course, saan mo pinafile yung petition ay kung saan, where the property is situated. You cannot, if the land is in, for example, I'm in Southern Leyte now, you cannot file the petition in Cebu. You cannot file it in Manila. You cannot file it in Bohol. File it in the province. Specifically, kung ang court ay nasa town mo or sa city mo, doon mo i-file ang petition. Okay, of course, i-sign mo yan. Tapos, may i-subscribe mo yan. Kasi nga, diba, sworn to, a sworn petition, meaning, ipanotarize mo sa isang notary public dyan sa lugar mo. Alright? So, yun ang form ng petition. Simply, di ba? Kaya mo bang gawin yun without the assistance of a lawyer? Siguro naman kaya yon. Tapos ipanotarize mo lang. Siguro, yung challenge mo dyan pag nag-hearing na, kung kaya mo rin bang mag-present, no, ng mga evidence mo without any lawyer. Pero pag kaya mo naman, wala namang sinabi ang PD 1529 na only petitions na assisted by lawyer ang pwede. Hindi naman kailangan. Okay? So at least alam nyo na kung paano. Tingnan nyo lang ang Section 15 ng PD 1529. Okay? Baka sabihin nyo, attorney, ba't mo sinabi sa amin? Di, mawala na ng trabaho ang mga lawyers. No, I don't mind. Kasi nga, ang purpose natin is to educate and to help you out. Tingin nyo naman kaya, no? Walang problema yan sa amin, di ba? We can find other cases naman, alright, na kung saan hindi talaga pwede na walang abogado. O, di ba? So at least, we're helping you do your own thing kung kaya nyo naman. Di ba? Okay, so, yon. May survey ka na-file mo na yung petition sa court. Of course, may mga babayaran yan, di ba? Filing fee and all those. So, maghanda ka lang ng mga filing fee. Hindi naman gaano kamahal yan, okay, yung mga filing fee sa court. You can ask the court ahead of time kung magkano yung payment ng filing fee. Now, the third step is of course yung court. Pagkatanggap ng court, yung regional trial court, pagkatanggap niya, so pag nakita naman sa judge na yung petition mo ay proper, no, informed, so the court will set a date for initial hearing. Okay? Ano tong initial hearing na ito? Of course, dito unang tawagin ng court, no, ang kaso, and then the court will determine kung may mga oppositors ba, kung may mga tao ba na nag-claim din sa property mo. And alam nyo, the first entity, the first person or entity na mag-o-oppose, palagi yan, by default mag-o-oppose yan, is the state. You know why? So kaya huwag kayong magtaka, bakit ba itong piskal na ito? Bakit ba itong solicitor general na ito? Bakit nag-o-oppose sa petition ko samantalang akin naman talaga ito? Balik na naman tayo sa Regalian Doctrine. Because the general rule is that this parcel of land, kasama yan sa land of the public domain. That under the Regalian Doctrine, these belong to the state. So yun ang general rule. And since ikaw ay gusto mong magiging sayo itong title ng specific land na ito, mag-o-oppose ang Estado. Kasi mababawasan yung land of the public domain. Mag-o-oppose ang state not for the sake of opposition na ayaw niya, but just to make sure na talagang may karapatan ka. Na talagang na-comply mo ang batas para magiging sayo yan. Number 2, para malaman kung talagang lupa na yan ay pwede mong mapagmamayari, no? Tama ba yung Tagalog ko? So kung pwede mo bang ma-own yan, okay? Kasama ba yan doon sa agricultural land ba yan? Kasi otherwise, pag forest land or timber yan, hindi mo pwede. So pag sa opposition sa state, ma-prove sa state that the land that you're applying is a timber land or a forest land, ayun, i-deny ng court yan, yung application mo. Or, national parks yan. O, kasama ng national parks. If you are applying title to the Puente Osmeña, if you're applying title to Fort San Pedro or Plaza Independencia in Cebu, or maybe the town plaza of your municipality, of course, the state will oppose, and if the state represented by the Solicitor General, normally i-deputize ang mga piskal natin dyan, mga prosecutor, pag na-prove nila nga national park yan, siguradong madi-deny din. So make sure na hindi timberland or forest land or national park ang in-applyan mo. Dapat agricultural land at saka alienable and disposable. Sinabi ng A&D. So pag narinig mo yung A&D na yan, alienable and disposable land of the public domain yan. So, pwede mong applyan ng title yang lupa na yan. Alright? So, set ng hearing ng court, initial hearing. Okay, then, yung clerk of court naman ng court, pagkatanggap dito, ita-transmit, no, yung application mo at saka yung notice of the initial hearing with the evidence, yung mga ina-attach mo, di ba, sa petition mo, ita-transmit yan ng clerk of court to the Land Registration Authority. Okay? Kasama yan sa requirement. Otherwise, pwedeng mag-oppose, no? Or mag-file ng nullity yung state, yung gobyerno sa proceedings pag hindi sila nakatanggap galing sa clerk of court sa itong sa transmittal na ito. Then, pagkatapos niyan, before the initial hearing, ipapublish, okay, yung notice of initial hearing, ipapublish yan sa Official Gazette. Ito yung official na publication ng Republic of the Philippines. Isang libro ito, Official Gazette. Doon yung mga official notices and announcement pinapublish. And also, aside from the publication sa Official Gazette, ipapublish din yan in any newspaper of general circulation. Okay? Kailangan ito and ito hindi lang or. So, dapat Official Gazette. Then, pagkatapos ma-publish, no, sa Official Gazette and newspaper, kailangan din, no, i-serve. Meaning, ibigay ang kopya ng notice of initial hearing doon sa occupants, di ba? Pag may nakalagay doon na occupant sa petition mo, sa property, and then, yun ding mga adjoining owners, di ba? Sasabihin mo doon yung mga pangalan nila, and all interested parties, for example, again, yung bank, pag na-mortgage ito, yung lending institution, or yung tao na inuutangan, di ba, ng may-ari, at saka ginawang guarantee itong property, dapat bigyan din sila ng kopya ng notice of initial hearing. At least alam nila na nag-apply ka. Okay? And of course, they will be, well, sa kanila na yon if they will attend the initial hearing. Basta they are notified. Okay? Then, pagkatapos niyan, everything is set. Initial hearing na-publish na, then na-serve na yung kopya ng notice of initial hearing, then yung lahat na tao na may opposition or may interest in that particular property, dapat mag-file sila ng answer or opposition. In my experience, ang state, magpa-file talaga yan ng opposition. Represented by the Solicitor General, and later on, i-deputize yung prosecutors natin diyan sa province, okay, or sa locality or sa city mo, mag-oppose talaga yan. If you look at the opposition, standard yan. No? That the property is, that the land applied for is land of the public domain, and the applicant has not complied with the requirement to own that parcel of land, blah, 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 blah. Okay? Meaning, ang state ay magsasabi, no, hindi. Itong property nito is part of the public domain. So, hindi pwedeng titulan yan. Huwag kayong magalit sa Estado. Huwag kayong magalit sa Solicitor General. Huwag kayong magalit sa prosecutor pag ganun ang mabasa nyo na opposition. Kasi, trabaho nila yan. Because again, the applicant or the petitioner has the burden of proof na sa'yo yung burden, no? yung obligasyon, yung responsibility to prove your title. Okay? So, normal yan. Yung iba naman, baka may ibang claimant, of course, magpa-file din ng opposition yan. Or siguro yung mga occupant, mag-file ng answer, sabihin nila, well, bahala ka, applyan mo yan. Basta ako, naka-occupy ako, may right ako to occupy. So, depende sa nature sa possession niya or occupation niya. Baka sabihin niya, uy, naka-lease, may lease contract ako sa previous owner. You have to respect it. Bahala, ma-applyan mo ito ng title sa'yo, but you have to respect my lease contract. No? For example, my lease contract is 20 years. So, okay, I will not oppose your application of title kasi na-acquire mo yan sa owner, pero respect my possession as a lessee. Pwedeng ganon, di ba? So, yun. Dapat file nila yung answer at saka opposition. And then pagkatapos niyan, pagdating sa time ng hearing, of course, may hearing. Now, anong ma-expect natin sa hearing? Di ba? Kasi usually, yung time na is set yan ahead. Yung bigyan talaga ng ample time na i-comply lahat yun. Yung publication, yung service, and all that. Okay. By the way, hindi nakalimutan ko. One way to publish also, isa sa mga requirement hindi nasabi dito, but in practice, yung notice of initial hearing ay ipopost yan doon sa bulletin. Saan bulletin? Bulletin doon sa court. Sa labas ng court, may bulletin board yan. Ipopost yan doon. And yung iba, in practice, yung mga sheriff, ipopost din nila doon sa, for example, kung saang munisipyo, ang property, ipopost nila sa bulletin board sa municipal hall. Or pag sa city yan, sa city hall. Okay? Or pag provincial, doon pa sa Kapitolyo, ipopost nila yon as a matter of due process. As a matter of, due process. Di ba sinabi ko at the start ng series na ito that the torrent system is basically a matter of notice. Bigyan mo ng notisya ang lahat ng tao that you are claiming title over this. So, lahat ng means, pamamaraan na this will be accomplished, yung notice na ito, it has to be done. Publication, service of the notice, and posting. Gagawin yan. Alright? So, hearing. Anong mangyari sa hearing? So, expected, mag-a-appear yan si Solgen doon. Pag hindi, ahead of time, dinideputize na. Binigyan na ng authority si prosecutor. So, mag-appear yan. Di ba? Tawagin sa court yung kaso, then of course, you will enter your appearance. Pag may lawyer ka, yung lawyer mo. Pag hindi, sabihin mo, appearing for the petitioner or applicant, Your Honor. Of course, ang state magsasabi, yung fiscal, appearing for the state, Your Honor. Okay, siguro may opposition na nag-file. Diyan ang fiscal. Tsaka yung iba naman na nag-file ng answer, mag-a-appear din yan. May mga panahon, okay, na walang nagpa-file ng answer, only the state, so fiscal lang ang nag-appear dyan, yung prosecutor. Pag walang ibang tao, anong gagawin ng court? Sabihin ng court, okay, interpreter, yung interpreter ng court, okay, read the petition. Basahin dyan doon sa courtroom. Okay? Na in the matter of the application for judicial title filed by so-and-so of the lot number so-and-so, okay? This is the initial hearing. So, any oppositor or any person interested, tatawagin yan. Pag walang sumasagot, of course, aside sa fiscal, walang sumasagot, babasahin na naman uli yan 3 times. 3 times yan, babasahin na may petition na ganito. Pag walang nagsasabi na, Your Honor, nag-o-oppose kami pag wala, pag tahimik, okay. Yung ikaw pag petitioner ka, okay, pag may abogado ka, walang problema kasi alam ng mga abogado ito. Pero pag ikaw lang, maghihingin mo sa court. Ito, importante ito. Okay, hingin mo sa court nga, Your Honor, I'd like to request for a declaration of general default. Ano itong declaration of general default? Okay, ang ibig sabihin yan, because of the publication, because of the service of the notice of the initial hearing, because of the posting, sabihin mo na, Your Honor, pinaalam ko na sa lahat ito. Na-publish na lahat-lahat pero walang nag-attend dito. So, ibig sabihin, wala nang ibang interesado sa property na ito. Bukod sa state, so, ang declaration of general default, ang sabihin doon na lahat ng tao na may interest ay declared in default na. Meaning, hindi na sila pwedeng later on mag-file ng opposition, hindi na sila pwedeng mag-file ng answer, hindi na sila pwedeng mag-participate sa subsequent proceedings kasi nga defaulted na sila. Binigyan na sila ng ample time pero since wala silang pinafile, they are declared in default. So, in this way, supposedly, mas madali na ang application mo. Pero it does not mean that automatic na ma-grant yung application mo. Kasi meron pang opposition yung state. You still have to prove your title. Pero at least, yun na lang ang i-focus mo, i-prove mo na lang that that parcel of land can be taken out of the land of the public domain. Okay? Walang ibang private individuals na involved. Okay? So, importante, huwag mong kalimutan, pag walang nag-attend dyan, maghingi ka ng Declaration of General Default. Okay? Now, so pagkatapos ng hearing na yan, iset mo na yan. Normally, ito kasi, lalo na pag walang oppositor, pag ang state ay yung standard na opposition lang yan, minsan ina-assign lang yan sa clerk of court to receive your evidence. Kasi documentary naman ito, di ba? Meaning, mga documents lang naman ang proof of ownership mo. Unless if you want to present mga witnesses, if you are claiming title by prescription or your possession, pwede ka ring mag-present ng mga tao, mga matatanda na nasa malapit doon na they can attest that you've been in possession of the property for so long. Pwede din yan. So, pero pwedeng i-assign yan sa court, doon sa clerk of court, for the reception of evidence. So, doon lang kayo sa chamber or sa court na kayo lang. Of course, nandyan siguro ang prosecutor para tanggapin yung mga ebidensya mo. Okay? So, pagkatapos niyan, may decision na gagawin ng court. I-promulgate yung decision. Whether to grant or deny your petition. Pag nag-grant naman, okay. Pag na-deny naman, you have an option. You have a remedy to appeal. Okay? Pero let's just assume na nag-grant, for our purpose, for our discussion today. Pag nag-grant yan, at saka hindi nag-appeal, okay, yung state, okay, mag-issue ang court ng decree. Okay? Decree of registration. So, may decision, tapos yung decision, pag naging final, may decree of registration. And then, yung decree na yan ay i-enter yan doon sa Land Registration Authority, doon sa National Repository. Okay? I-enter yan doon yung decree. So that's why if you notice, mamaya ipakita ko yung title, yung sample, may decree number yan. Okay? Bukod sa decree number, ito, ipa-flash ko yung sample ng original certificate of title. Tignan mo, meron yang decree number. Meron ding LRC number yan. So meaning, yung case number sa court, sa RTC, makikita mo yan doon. Bakit importante ito? If you want to research, okay, pag nabili mo yung property na may torrents title, pwede mong tingnan doon kung talagang na-follow ba yung procedure. Okay? May LRC number yan. Yun ang case number doon sa RTC. Tapos yung decree number, yun ang decree na doon na naka-enter doon sa Land Registration Authority. And then, pagkatapos pag na-enter na itong decree na ito, i-forward yan doon sa Register of Deeds kung saan located yung property. So, anong gagawin ng Registry of Deeds? I-transcribe yung decree doon sa registration book. Meaning, i-enter din sa book ng Registry of Deeds yung decree na yan. And yung Registry of Deeds ang mag-issue na ng original Certificate of Title sa iyo. So, itong pina-flash ko na original Certificate of Title, ang Registry of Deeds, Registrar of Deeds ang mag-issue sa iyo nito. Ito na yung proof of ownership mo talaga under the torrent system. Kaya tinatawag ito na torrents title. So may torrents title ka na sa property mo na ito, and then from then on, itong property na ito ay matatawag na registered land. So hindi na yan unregistered, registered land na yan. Na binyagan na yan. Kung we have an analogy, binyag na yan, may identity na yan, may lot number na yan, may meets and bounds na yan, at saka may nagmamay-ari na, may owner na, which is you. Kasi nandoon yung pangalan mo as owner. Tingnan mo itong sample na ito, di ba? May owner dyan. Saka sa likod niyan, may technical description. So, buong-buo na ang pagmamay-ari mo sa property na ito. Tanong, so what if I have the torrents title? Next episode, i-discuss natin yan. What's the significance of this torrents title? We will discuss that. Very important. At alam mo ang ang value ng hinahawakan mo na Torrens title after na follow mo, no? Itong napaka-tedious na process in acquiring title by judicial process. Okay? So, that's the formalities, no? The requisites for land registration under Act 496 and under PD 1529. Okay? So, thank you for watching. And again, send in your questions by typing in the comment section below or sending a message to our Facebook page, Attorney Rico Rentuza, Law at Home. And if you want to help people also gain this information, okay, please like, share our video and our page to your friends and family members, and subscribe to our YouTube channel where you can find this video and the previous episodes. If you want to review the videos that we had before, you can, if you subscribe there and you click on the notification, the bell button there, you will also be notified of the new videos that we are posting there. Okay? So thank you so much. Thank you so much for watching. And again, this is Attorney Rico Rentuza saying and reminding you to stay at home, stay away from legal trouble. Thank you and see you next episode. Bye-bye. God bless you.